Good afternoon, everybody. We'll start off with an apology, but obviously we had votes, and that's the first order of business. At this time, I want to call this forum to order, and I'd like to begin by thanking House Administration Chairman Dan Lundgren for allowing us to use the committee room. The past 2 years since the Supreme Court's decision in Citizens United have seen a revolution in campaign finance laws, and it is time that we looked into it. Even before Citizens, the Jack Abramoff scandal and others showed how corruption damages our nation. But even the appearance of corruption is destructive. 75% of Americans believe campaign contributions buy results in Congress. That is a threat to our democracy itself. We have waited 15 months for the Committee of Jurisdiction to hold hearings. We can't wait any longer. I'm only sorry this is the first discussion the House has held on this subject, and the only hope is to see official hearings someday. But we will do what we can to bring light to the issue. Since Citizens United, we have entered a different world. As we see on Chart 1, outside spending in campaigns has drastically increased. The spending on the most expensive campaign for the House of Representatives rose from $1.7 million in 1990 to $11.7 million in 2010. Spending by groups that don't disclose their donors increased from 1% to 47%. Chart 2, as you can see. Part of this has been facilitated by this new invention referred to as the super PAC. And we will have a clip on what, in essence, is a super PAC.
Between a PAC and a super PAC?
Well, it gets technical, but without going into too much detail, one of them has the word super in front of it, and that makes it a super PAC. Other than that, as far as I can tell, the difference between a PAC and a super PAC is a cover letter, because I formed a PAC, but a PAC can only take so much money and can only spend so much money. And I wanted to spend unlimited amounts of money and receive, more importantly, unlimited amounts of money. And so my lawyer told me all I had to do was add a cover letter that said, I intend this to be a super PAC. And it was a super PAC.
So now you can take all the money that people are unwise enough to send you?
Any amount. Did you bring a checkbook?
Of course. How much money have you collected so far?
Oh, the fun thing about that is I don't have to tell you.
What was the Supreme Court thinking? The justices were fully aware of the threat that is posed by political contributions to judges who run for judicial posts, but they saw no such threat to the legislative branch. And we know that Justice Scalia laughed at the idea that people who sign political petitions should remain anonymous because, as he said at oral argument, quote, the fact that running a democracy takes a certain amount of civic courage. And the First Amendment does not protect you from criticism or even nasty phone calls when you exercise your political rights to legislate or to take part in the legislative process. In his concurring opinion in that case, Justice Scalia was even more blunt, requiring people to stand up in public for their political acts fosters civic courage, without which democracy is doomed. Yet an individual or a corporation can remain anonymous when making a monetary contribution. And we should also have a clip here on how that can be done and effectuated.
Okay, so now I can get corporate, individual donations of unlimited amount for my C4. What can I do with that money?
Well, that C4 could take out political ads and attack candidates or promote your favorite ones, as long as it's not the principal purpose for spending its money.
No, my principal purpose is an educational entity, right?
There you go.
I want to educate the public that gay people cause earthquakes. Okay.
There are probably some C4s doing that.
Can I take this C4 money and then donate it to my super PAC?
You can.
Well, wait, super PACs are transparent.
Right.
And the C4 is secret. So I can take secret donations of my C4 and give it to my supposedly transparent super PAC.
and it'll say given by your C4.
What is the difference between that and money laundering?
It's hard to say.
Well, Trevor, thank you so much for setting me up.
Now, Mr. Colbert may be using satire, but his point is very real. Phony corporations have been set up to disguise donations. WSPAN LLC gave $1 million to the super PAC Restore Our Future, and only investigative journalism and the donor's embarrassment revealed the millionaire behind the money. There are criminal probes into other such donations, but some are completely legal. It used to be that every politician, whatever else they thought about campaign finance reform in general, was for disclosure. There's a list of old quotes on the press table that are available to those that want to see those previous positions taken by the same individuals that would oppose disclose today. All that, of course, has changed, as I just mentioned. Even some of the biggest donors to super PACs are opposed to the idea of unlimited donations. One prominent contributor whose family has contributed more than $15 million to a super PAC said, quote, "I'm against very wealthy people attempting to or influencing elections, but as long as it's doable, I'm going to do it." I'm sorry that none of the major super PAC donors accepted my invitation to testify today, but we do have 4 panelists here today that are very familiar with the subject and some very articulate members of Congress that are supporting that which we can do in the way of disclosure. I will begin by recognizing the distinguished Democratic leader, Nancy Pelosi, for an opening statement.
Thank you very much, Ranking Member Gonzalez, for your leadership in bringing us here today on this important issue, so important that it is fundamental to our great democracy. I'm honored to be here with you and with our ranking member of the full committee, Congressman Brady, and our other colleagues, Congressman Chris Van Hollen, author of the Disclose Act, with David Price, a respected member of Congress who brings academic as well as governmental credentials to this discussion, Keith Ellison, Congressman Keith Ellison, who is working at the grassroots level to try to offset some of the cynicism that is growing regarding the use of money in campaigns, and Congressman Capuano, who a respected member of this committee, who's worked hard on this issue. It's important because our founders had intended that we were a democracy, which meant we were a government of the people, and that the votes and the voices of the people would determine the outcomes of elections, not the bank books of a very few people. Nearly a century ago, Supreme Court Justice Louis Brandeis wrote about the dangers of corporate interests dominating our economy, stifling competition, and harming our nation. And he reminded us in the face of these forces that sunlight is said to be the best of disinfectants. We agree. Today, we come together in that same tradition to shed sunlight on our democratic process and preserve the integrity of our elections, our democracy, to call on our colleagues to protect the voices and the votes of the American people. Our effort today is necessary because more than 2 years ago, with a Citizens United decision, the Supreme Court opened the floodgates of uninhibited special interest spending, secret undisclosed spending in our elections, and unlimited corporate influence over our public policy debate. In response to the Citizens United ruling, Democrats have worked to restore transparency, fairness, and accountability to our political process. We have worked to create what we believe is necessary, a new politics free from special interest and big money. It's with that goal in mind that today we've come together for a forum. Thank you, Mr. Ranking Member Gonzalez and Mr. Brady, for a forum called The Most Expensive Seat in the House, the State of Our Campaign Finance System. While I appreciate the recognition that Ranking Member Gonzalez made to the chairman who gave us permission to use the room, I think it's really necessary to say, if you need any more argument about the need for openness, you only need to look to the fact that the chairman denied us the ability to use the cameras, the room's built-in cameras, so that we can transmit what is happening here more fully. In fact, the Republican majority has denied us hearings on legislation called the Disclose Act, which would require corporations to report their campaign-related activities, and as Mr. Van Hollen leads us in saying, calling upon them to stand by their ads, the same way candidates must do. Already 160 members have co-sponsored this legislation, and I hasten to add that Mr. Brady, when he was chairman, enabled the Republicans and the minority to have at least 3 hearings at their request. We hope that the Republican majority will enable this to be a full-fledged hearing. They won't let this proceeding be called a hearing, so it is a forum. This legislation, the Disclose Act, passed the House in 2010 with bipartisan support, only to be blocked in the Senate by the Republicans. We must fight for full disclosure to get unlimited secret donations out of our politics. We must fight for reform to empower small donors and the grassroots to have a greater role in our elections. And I contend that when we reduce the role of money in politics, and not just Citizens United, but all big money in politics, we will increase the number of women, minorities, and young people in elective office. It will have a very wholesome impact on our system. Ultimately, we must fight to amend our Constitution to overturn the Supreme Court decision that have strengthened the hands of the special interest at the expense of the people's interest. So I'm very honored to join my colleagues in welcoming this very distinguished panel to our forum today. Norman Ornstein of the American Enterprise Institute, Paul Ryan, FEC Program Director, Zyver, like the wind, Teach Out, Professor, Fordham University School of Law, and Monica Yoon, Brennan Center Constitutional Fellow. They will be more appropriately introduced. But today's forum, this effort, is about nothing less than our democracy. The votes of the many must determine the outcome of elections, not the bankroll of the very privileged few. With that, Mr. Chairman, I once again commend you for holding this forum and salute you for your leadership on this subject.
Madam Leader, thank you. Thank you for your leadership and your participation today. To the witnesses, you will be given 5 minutes to make their oral remarks. If you've submitted anything in writing, please understand that will become part of the record, and you can supplement that, of course. But we're going to try to keep it to 5 minutes, and then we'll have Q&A, and maybe even a second round of Q&A. Our first witness is Norman J. Ornstein, who received his BA from the University of Minnesota and a master's and a PhD in political science from the University of Michigan. Dr. Ornstein is a longtime observer of Congress and politics. He writes a weekly column for Roll Call and is an election analyst for CBS News. He served as coordinator of the American Enterprise Institute Brookings Election Reform Project and participates in AEI's Election Watch series. He also serves as a senior counselor to the Continuity of Government Commission. Mr. Ornstein led a working group of scholars and practitioners that helped shape the law known as McCain-Feingold that reformed the campaign finance system. He was elected as a fellow of the American Academy of Arts and Sciences in 2004. His many books include The Permanent Campaign and Its Future. He co-authored The Broken Branch, How Congress is Failing America and How to Get It Back on Track, and also has co-authored the most recently Vital Statistics on Congress 2008. And with that, I'll turn it over for testimony by Dr. Ornstein.
Thanks, Mr. Chairman, Madam Leader, and members of this panel, many of whom I've worked with on some of these issues. I do have a written statement. I just want to make 3 quick points. The first is about the Citizens United decision, a decision that I think has reverberated around the country, and I've seen it in my own travels and discussions with people more than any other in the last several decades. The first thing I want to say is I actually have never seen a decision more poorly reasoned or removed from reality as this one. The idea, first of all, that corporations should be treated the same as people when it comes to political involvement when individuals in the society have a multiplicity of interests and motives, some of them very personal, related to their own lives, but others that reach out to the larger society and with an interest in the futures of our children and grandchildren. Corporations have one motive, which is profits. At the same time, the idea that money equals speech, the more money, the more speech, the better, flies in the face of another reality. If I'm speaking with my own voice or just with one microphone to amplify it, and you have 30-foot speakers and an amplifier that can shake the seats at Nationals Park, and we're both trying to speak at the same time, I don't view that as something that is good for dialogue in a society. But we've now created a situation where there is enormous leverage for those with those amplifiers. And I have to say that sitting in the Supreme Court, as it argued, had an oral argument over the McConish decision, another in a string of destructive decisions made by the court, the logic applied there, which was involving the public funding system in Arizona, where if a multimillionaire spent significant sums of his or her own money and opted out of that public funding system, that the candidate who had opted in could raise a little bit more money. The idea that that would damage the speech of the multimillionaire was a kind of logic that it seemed to me belonged on another planet or in another galaxy, but that's what we're talking about here. And finally, the idea in Citizens United and Justice Kennedy's decision that independent expenditures can't be corrupting also belongs in another galaxy. The point I would make there is for anybody who's been for more than 10 minutes around the halls of this body or in any legislative body, but now especially in the aftermath of Citizens United, watching the pressures to raise money, watching what happens when members no longer have to worry simply about competing against a candidate, but against now the nightmare that with 3 weeks to go in an election, some alien predator group anonymously can parachute in behind your lines and spend $20 million to slime you. And you have to raise money in small increments, there's no time to do it, has put everybody on notice that they better raise war chests in advance. And that means whether you're in this building or standing outside, watching members stream out in any odd moment to do call time, which has now become far more significant, and knowing what, as a member of this committee, Barney Frank, has said, the demeaning process of having to go out and either beg for money or shake people down. If that's not corrupting, I'm not sure what is. And frankly, the independent amounts, the large amounts that can be spent, the unlimited amounts, I've had lots of people, senators in particular, tell me of their experiences sitting down with somebody who says the equivalent of, you know, I'm working with Americans for a Better America, and they've got more money than God. They really want this amendment. And if anybody challenges them and doesn't do it, I don't know what they'll do, but $20 million in the last few weeks of a campaign, that's not beyond them. The result is we not only will have more money, but we're going to have more amendments, more provisions that nobody will know about without a dime being spent. That's what unlimited money can do. My final point is this is a problem with the Supreme Court. That's a big lift until we get a change in the court. We have to turn to other agencies where we can begin to get some other impact that can bring us back to true independence instead of the farce that we have now that Stephen Colbert and our colleague Trevor Potter have pointed out so well, and to real disclosure. It would be nice if we could have gotten, so it would have been nice if we had gotten one Republican in the Senate to support the Disclose Act, including those who now talk eloquently about the need for it in the last Congress. It would be nice now if we can get a Federal Election Commission not to deadlock 3-3 on almost every instance in which we enforce the law. The problem is not just Citizens United, it's that laws on the books, everybody who's involved in this process knows you can do almost anything that you want. I hope you will support the Federal Communications Commission as it moves forward now commendably with its action to require broadcasters to put in their public file online in real time the donors to the ads that they're giving, which is being resisted strenuously by the same broadcasters who are making billions of dollars in profits from all of the ads that are going up. And I hope that you will also work with the IRS to enforce its own regulations and the Securities and Exchange Commission to require public corporations to disclose all of their expenditures in this area. And finally, let me just say, it's worth thinking about an idea that's been raised by a lawyer named Gregory Colvin to introduce a law that would limit the political expenditures of 501c4s. I'm not sure how much we can rely on the IRS, and it may be worthwhile as well to pass a law that makes this more explicit. Thank you very much.
Thank you very much, Dr. Ornstein. I'm going to be going a little out of order. Don't mean to throw you all off, but the next witness is going to be Monica Yoon from the Brennan Center, Constitutional Fellow. Her education consists of a BA from Princeton, a Master's in Philosophy from Oxford, and JD from the Yale Law School. Monica Yoon is the inaugural Brennan Center Constitutional Fellow at NYU School of Law, where she focuses on election law and First Amendment issues. She is the editor of Money, Politics, and the Constitution, Beyond Citizens United, a book of essays by leading constitutional scholars, and she has published law review articles on election law issues. She has litigated election law cases in federal courts across the nation and has testified before Congress on multiple occasions. Her political commentary has been published in Roll Call, Slate, the LA Times, among other publications. She has appeared on MSNBC, PBS, the NewsHour, Democracy Now!, and the Bill Moyers Journal. Her work at the Brennan Center has been recognized by the New Leaders Council, which named her one of their 40 under 40 nationwide leaders in 2010, and by Common Cause, which awarded her the John Gardner Award for Extraordinary Leadership. Ms. Yoon.
Well, it's 6 months out from the general election, and it seems a little bit early for a weather report, but it seems already clear to everyone in this room and outside this room that the 2012 election is shaping up to be a perfect storm of money in politics. We have unprecedented levels of outside spending combined with massive loopholes in federal disclosure laws, which has led to a situation that is really kind of the worst of all possible worlds. I wanted to focus my testimony, first of all, on the definition and derivation of super PACs. I then wanted to talk specifically about what changed in the law between the post-Citizens United era and the pre-Citizens United era, and then to talk about, very briefly, about some of the faulty assumptions underlying the logic of Citizens United. So super PACs are the latest and greatest soft money loophole, a phenomenon that threatens to overwhelm our politics. Unlike the other major players in campaign fundraising, candidates, political parties, and traditional PACs, super PACs have a court-conferred advantage. They do not have to play by the same fundraising rules as everyone else. Those other entities are all bound by federal contribution limits, which regulate both the source and amounts of contribution, and none of those entities can receive contributions from corporate or union general treasury funds. By contrast, super PACs can raise and spend unlimited funds not only from wealthy individuals but also directly from corporate treasuries, and because of loopholes in federal election disclosure laws, including the C4 loophole discussed by Stephen Colbert, and the anonymous shell corporations also created by Stephen Colbert, many of the sources of these funds remain cloaked in secrecy. So this morning's LA Times, for instance, reported that Crossroads GPS, which is the C4 that funds American Crossroads, has received $77 million in undisclosed donations, money that we can expect to have a major impact on what happens with on the electoral spending that Crossroads GPS is permitted under current laws to engage in. We don't know who these donors are. We don't even know whether these donors are individuals or whether they are corporations. So how do we get to this state of affairs? There's been a lot of debate over whether the Supreme Court created super PACs in its Citizens United decision. I find a lot of that discussion, frankly, beside the point. The Supreme Court didn't create or even mention super PACs. Super PACs didn't exist at the time of Citizens United. But the logic of Citizens United directly dictated that when the D.C. Circuit heard the case, Speech Now, that created super PACs, it had no choice but to follow along with that reasoning. So what's actually changed? Because a lot of people will say, well, you know, this is politics. Politics ain't beanbag. There was already corporate money in politics. There were already wealthy donors pouring millions of dollars into independent spending. But, you know, prior to Citizens United, corporations and unions could participate in politics, but they had to do so through their separate segregated funds or PACs. These consisted, crucially, of money that was limited and money that was voluntarily contributed by individuals, by shareholders, by corporate officers. And so they had to abide by the same fundraising rules as everyone else, go hat in hand and say, hey, who wants to support the corporation's political agenda? So, for example, in the 2008 election cycle, ExxonMobil did exactly that. They went around hat in hand to their employees' shareholders. They collected about $700,000, which is a very respectable amount of money. But during the same election cycle, ExxonMobil's corporate profits were $80 billion. That's a difference of more than 100,000 times. And what Citizens United does is it allows the amount of money that every corporation has available to it to act as a potential election war chest to increase by these kinds of exponential figures. After Citizens United, corporations can spend money, often through a shell corporation or other loophole, and do so in an undisclosed manner. So secondly, about wealthy individuals. So some people have said, look, we all know about the Wiley brothers way back in the day. We know about George Soros, all spending money, you know, the Swift boat advertising. You know, wealthy donors have always poured money into politics. But that money had to be disclosed. Now that donors can cloak their electoral influence in secrecy, we're seeing dark money overwhelm the system. So as these slides will show you, the amount of total outside spending until March 8th of this year was $88 million, which is more than twice as much as 2008 and more than 6 times as much as in the 2004 cycle. So now that that money is in the dark, we're seeing individual wealthy donors just flood to this new dark avenue. So why did the court do this? And without I'm out of time here, so I'm just going to briefly mention the 3 faulty assumptions that underlay the court's reasoning in Citizens United. First of all, that independent expenditures are truly independent. As I explained in my written testimony, that would depend on having a workable definition of what constitutes a coordinated expenditure, a definition that the FEC has utterly failed to promulgate or to enforce. The second, that existing disclosure laws will protect against corruption. Corporate political spending is not required to be disclosed either to shareholders or to corporate boards or to voters. It's very easy to keep this law in the dark, but even if disclosure laws worked, disclosure is necessary but not sufficient. Disclosure points out the outliers, but it doesn't really take care of the heart of the problem. And thirdly, that quid pro quo corruption is the only problem Congress can constitutionally protect again. As Mr. Ornstein mentioned in his testimony, we now have lots of instances of Americans for a Better America or other similarly euphemistic wealthy interests throwing their weight around and acting in a way that's utterly unaccountable. This may resemble an oligopoly, this may resemble a plutocracy, but it very little resembles what we have come to think of as democracy. Thank you very much.
Thank you very much. Excuse me. Next witness will be Cypher Teachout, Associate Professor of Law, Fordham University School of Law. Received her education, her BA from Yale University, her Master's in Political Science from Duke, and her JD from Duke. She is a talented and very creative scholar. Professor Teachout brings a rich background in laws governing political behavior, both domestically and abroad, as well as the insights of her original work on corruption and its constitutional history. Her 2009 article, The Anti-Corruption Principle, was cited by Justice Stevens in his Citizens United dissent for showing, among other things, that the founders, quote, discussed corruption more often in the Constitutional Convention than factions, violence, or instability. Professor Teachout.
Thank you so much. It's Zephyr.
Okay.
Thank you so much for having me. I'm going to do two things in my remarks. First, talk about history, and then talk about the future. I want to place Citizens... Is that better? I want to place Citizens United in a broader historical context. As a friend of mine, a Texas lawyer who taught at Duke, said about Buckley versus Vallejo, they went and got drunk on the First Amendment, didn't they? And since Buckley versus Vallejo, the last 30-odd years of jurisprudence have been wildly outside the initial 180 years of thinking about the First Amendment and thinking about Congress's power to limit corruption through political regulation. Up until Buckley, it was not a sensible argument to claim that Congress couldn't do what it needed to do to prevent money overcoming political power. Just one of many examples. In 1874, the United States Supreme Court refused to enforce a contract between an old man and a lobbyist because they said lobbying was against the public policy of the United States. And if the great corporations of our day were to hire adventurers to lobby in the halls of Congress, that would corrupt and degrade the entire institution. Several states had laws criminalizing lobbying. And certainly up until Buckley versus Vallejo, the assumption was that one could limit campaign expenditures as well as contributions. Since Buckley, you know somewhat from what others have said about the eccentricity of the court in the context of campaign contributions, but there's been a parallel eccentricity in interpreting federal bribery and extortion statutes. So in 1991, the Supreme Court says even though many campaign contributions would otherwise count as extortion or violation of federal extortion laws, in this area alone, we are going to require a specific promise on the part of a legislator in return for a donation, so that we're going to carve out an exception within federal bribery laws and say, here, when it's campaign contributions, it's not bribery. So this creates this incredible bait and switch. Because in the context of bribery laws, we say, don't worry, campaign finance laws will cover it. And then in Citizens United and other cases, Kennedy says, don't worry, bribery laws will cover it. And what you end up is this great cavity where what you and I and the rest of the country knows is corruption in the sense the founders meant is allowed to go on. So we are, as Monica suggested, in this terrible world where you spend all your time begging for people to give you $2,500 and to bring people together who can give you that much. And at the same time, you need to be then scared of the company that might come in or might not and roil your local constituency with and swarm it with ads. If you don't change this, you know and I know and the country knows it's a bad couple of years, but it's about to get much worse. The culture of corporations has not yet adopted the Citizens United law. They have not yet hired the best campaigners. They have not yet figured out all the loopholes. This is 2 years in. So it's so important to do something now. Now, I'm a former national director of the Sunlight Foundation, I'm a former political campaigner, and I'm a scholar. I think disclosure is extremely important. But I do not think you can X-ray a sick patient into health. And I do not think that X-rays alone are sufficient and disclosure is alone sufficient for the level of threat that we have right now in this country. It is critical that this Congress focus on changing the structure of the way campaigns are funded, low-dollar matching funds. I know, I was the director of online organizing for Howard Dean's presidential campaign. We figured out, and you've seen Barack Obama do extraordinary things with this, we know how to allow you to spend your time talking to 100 people who give you $100 instead of the richest people in the world. You may lose your jobs fighting for changing the structure of money in politics. But if you don't do this, you can't do anything else. You can't do anything about too big to fail companies if you're scared about them coming into your district. You know that. You can't do anything about capital gains tax or the financial transactions tax with this kind of funding mechanism. So thank you for having me, and I look forward to seeing what happens.
Thank you. Next witness is Paul S. Ryan of the Campaign Legal Center. Paul S. Ryan joined the Campaign Legal Center in October 2004. He has specialized in campaign finance, ethics, and election law for more than a decade. Mr. Ryan directs the Campaign Legal Center's Federal Election Commission program and regularly represents the Campaign Legal Center before the Commission. Mr. Ryan also litigates campaign finance issues before federal and state courts throughout the United States and has published extensively on the subject of election law. Mr. Ryan has testified as an expert on election law before numerous legislative bodies and governmental ethics agencies, including the FEC, the California State Legislature, the California Fair Political Practices Commission, the New York City Council, the New York City Campaign Finance Board, the Los Angeles City Council, and the Los Angeles City Ethics Commission. Mr. Ryan has also spoken on the topics of campaign finance and ethics laws at conferences around the nation, has appeared as a campaign finance law expert on news programs of CNN, NBC, C-SPAN, and other media outlets, and has been quoted by the New York Times, Los Angeles Times, the Washington Post, Roll Call, and news publications. He received his education at the University of Montana, as well as the University of California, Los Angeles School of Law's program in public interest law and policy in 2001. Mr. Ryan.
Madam Leader, distinguished committee members, thank you for this opportunity to appear before you this afternoon. As you've already heard, the Citizens United decision was based on at least two faulty assumptions. First, that this new flood of corporate money in politics would actually be disclosed, and second, that this new flood of corporate money in politics would actually be spent in a truly independent manner with respect to candidates and parties. I'm going to address the nuts and bolts of existing statutes and regulations that undermine those two assumptions of the court. And these assumptions were only made worse by the D.C. Circuit Court of Appeals in the Speech Now case, which gave rise to the super PACs. Notwithstanding the Supreme Court's promise that the corporate money it was unleashing would be spent independently of candidates, current laws have been interpreted by the FEC to allow very close relationships between super PACs and candidates. Congress, in passing the McCain-Feingold law in 2002, ordered the FEC to rewrite its long ineffective coordination rules. These coordination rules have twice been invalidated by federal courts over the past decade and remain ineffective today. Many assume that the coordination rules restrict general interaction between candidates and outside groups, but instead, current coordination rules regulate only discrete expenditures, discrete ad buys, for example, made by outside groups. Current coordination rules accommodate close personal relationships between candidates and the individuals operating super PACs, and in fact, many of the candidate-specific super PACs active in this year's elections are being run by close associates and friends and former employees of these candidates. The McCain-Feingold law prohibits candidates and office holders from soliciting unlimited funds, as well as corporate and union funds in any amount, so-called soft money, in connection with any elections. However, last year, the Federal Election Commission nonsensically issued an advisory opinion stating that candidates and their staff and office holders and their cabinet members can attend, speak, and be featured guests at these super PAC fundraising events where unlimited funds are being raised, so long as they do not make the actual pitch for the unlimited contributions. This is nonsense. The close relationships between super PACs and candidates fall far short of the independence likely envisioned by the Supreme Court in Citizens United. On top of this, we have 501c4 organizations. The Citizens United Court's second faulty assumption that disclosure laws would provide voters with the information needed to make informed decisions on Election Day has not come to pass. Section 501c4 organizations like Crossroads GPS will likely spend hundreds of millions of dollars on election ads in this year's elections without disclosing any of the sources of their funds. This is possible because back in 2007, the FEC promulgated a rule gutting the McCain-Feingold Law's donor disclosure requirement for electioneering communications, whereas the statute requires groups that spend more than $10,000 in a calendar year on electioneering communications to disclose the names of all contributors who contributed $1,000 or more to the group. The FEC's 2007 rule, by contrast, narrowly restricts that disclosure requirement. It only requires disclosure if the donor gave the funds, quote, for the purpose of furthering electioneering communications, close quote. Under the FEC's rules, donors to 501c4 groups simply refrain from designating their contributions to the groups for any particular purpose and therefore evade entirely these McCain-Feingold Law donor disclosure requirements. Last year, Representative Van Hollen sued the FEC challenging this 2007 rule, and several weeks ago he prevailed in his challenge with a favorable decision from the federal district court. However, an appeal is pending, and the FEC is unlikely to act on this court order anytime soon. The Campaign Legal Center is very proud to be part of Representative Van Hollen's legal team, and we plan to continue fighting on his behalf in courts. The Campaign Legal Center urges Congress to pass the Disclose Act of 2012 to close these disclosure loopholes, to address these problems that have been made possible by the FEC's regulations as well as by holes in existing statutes. The IRS itself has a role to play in this as well. The IRS's faulty interpretation of the tax code has made 501c4 organizations attractive vehicles for spending these millions of dollars in election ads while shielding their disclosures. I'm happy to talk further about the tax laws to the extent that it interests you, and I thank you for this opportunity again to testify before you today.
Well, we thank the witnesses. We're going to proceed with 5 minutes of questioning from the members that are up here right now, and I will start by recognizing my colleague, Mr. Brady.
Thank you, Mr. Chairman, but I would yield my time. Just real quickly, do you think any, and this is for all of you, the Disclose Act, do you think that's a first good step that closes the gap between unions and membership organizations as opposed to corporations? And the reason why I make the distinction, I'm a union member, and I'm still a current union member of 2 unions, and every donation that I make, I vote on. I get a chance to vote when I have our meetings and submit the request of people or whoever it may be, organizations that ask for donations, and we get a chance to vote on them. And membership organizations the same. Corporates, they just do what they want to do with any money that they collect. And the problem I have with that is a pen is a company. TVs are companies. Water is companies. These guys, God knows, are companies. Watches, jewelry, clothes. They're all companies that we all support. And we buy items from them, and they make a profit. And then they can use that money, our profit, or the money that we give them, they can now use that against me. They can use that against any one of my colleagues. And I have a problem with that. I have a problem with that transparency. And talking about transparency, as our speaker, our majority leader just had said, that they had asked us, me as the chairman of this committee, for us to have hearings on the Citizens United and Disclose Act. And, you know, there's a lot of things above my pay range, and naturally I have to go to my speaker at the time, Speaker Pelosi, and ask her if we should do that. And she said, yes, give them as many as they want. They wanted 3. We have on our committee, myself, Mr. Gonzalez, Mrs. Lofgren, asked for a hearing on the same exact way they asked us, and they said no. And then he won't even put our pretty faces on TV and let us even let the whole Congress, while we're sitting here waiting for a vote, that they could just watch and listen and form an opinion on what we're hearing here today from all of you. So, you know, that does upset me and bother me a little bit because, again, it's probably above our chairman's pay grade, but it's not above the leadership that sanctions it or not sanctions us to have these hearings. So do you think the Disclose Act, back to my question, is a good first step into closing that gap between our union membership and our and membership organizations as opposed to our corporations that are allowed to be in obscurity and do whatever they want, non-transparent? anyone who
I'd be interested in addressing that. I'm not prepared to talk about the Disclose Act, but there is a very interesting asymmetry because the Supreme Court in Citizens United pretends it's treating corporations and unions the same. And I think Representative Brady is absolutely correct in pointing out that, in fact, they're not the same, that the Supreme Court, among others, has been absolutely vigilant in making sure that every dollar of union member funds that goes toward political spending was put there voluntarily, and that members who are not interested in their money being used for political spending have an opt-out. Whereas corporations, the money that they're using is not voluntary. When I give my money to my 401k, I'm not saying that whatever corporate manager has their hands on my money has the right to use that to support any political candidate that they like. So so yes, unions and corporations can both spend out of their general treasury funds, but the asymmetry is in amassing those general treasury funds, unions are required to use only voluntary contributions, whereas corporations are not.
I'd also like to respond. The Campaign Legal Center strongly supports the Disclose Act of 2012. We think it would do great things to improve transparency in U.S. elections. When it comes to treatment of or spending by labor unions versus for-profit corporations, non-profit corporations like these 501c4 groups, it is the thresholds for disclosure that are intended to capture the information that matters, big donors. And the Disclose Act, I believe the donor disclosure thresholds in the Disclose Act of 2012 are $10,000. So it is only when a person or an entity, a corporation, gives money to the spenders in excess of that $10,000 threshold that they get disclosed by the spender as a donor to the group. I think that's a good thing. I don't think disclosure thresholds should be so low as to capture every dollar coming into these groups. It may place an unreasonable burden on groups that are funded or driven principally by a huge number of small donors. They don't worry me in terms of democracy. Large numbers of small contributions aren't the problems here. It's small numbers of huge contributions swaying elections that's what matters, that's what needs to be disclosed.
Just one quick comment. And I also support the Disclose Act, but I would take it further. The campaign monies given by corporations are non-deductible business expenses. If I'm a shareholder in a corporation, I ought to know when that company is spending money that is not for legitimate business purposes directly that would be deductible. And it seems to me that two things ought to happen here that perhaps you could participate in. One is to urge the Securities and Exchange Commission to promulgate a regulation that requires in annual reports that all non-deductible business expenses are disclosed. And the second is to talk to major shareholders, and that includes big pension funds, and have them go to corporations and demand that it's in their interest as shareholders to know how they're spending their money that doesn't get a tax deduction.
Thank you, and thank you all for being here today, and thank you, Mr. Chairman.
Thank you very much, Mr. Brady. We'll recognize Mr. Price for 5 minutes.
Thank you, Mr. Chairman. Thanks to all of you for outstanding testimony in every case. Very, very well done and very helpful. We all could multiply examples here of how far this has gone already and where it may well take us in the future. On March 30th, This American Life ran a show entitled Take the Money and Run for Office. And during the second segment, the show focused on a California race, actually the race of the chairman of this committee. 3 weeks before the election, the Times ran a piece calling incumbent Dan Lundgren endangered. Guess what happened? The next week, Karl Rove's super PAC, American Crossroads, dumped $680,000 into that race in the form of a media buy, and we all know the result. I had a similar experience right next door in North Carolina. My colleague Bob Etheridge in the 2nd District. Hundreds of thousands of dollars parachuted into that race the last 2 weeks, lost by very few votes. And needless to say, not one dime of that was spent on anything but negative ads. So the examples are multiplying. The future is before our eyes, I think, in what's happening this year, including the Republican presidential primary. And so I'd like to ask a couple of questions, which maybe help us understand the gravity of this and some of the consequences. All of you, in your own way, have spoken about corruption or the appearance of corruption and about the otherworldliness of the court's reasoning about that. I wonder about the effects on this institution and on the effects of the functionality of American politics and American government. And Norm Ornstein, I want to ask you to start on this because I know you've thought about it, but I expect all of you have. How is this money spent, and in what ways is it spent differently from money spent by other kinds of political groups? Are these ads different? Are they more negative? Are they more personal? Is there any study of this? I mean, we all have our impressions. I wonder if those impressions are confirmed. And what effect does this avalanche of negative ads with undisclosed sources, what effect is that likely to have on what we all know is an overly charged, overly polarized political environment that we're already dealing with the dysfunctionality of this institution, our inability, our failure to come to grips with the major issues of the day? We can't even pass a transportation bill. We can't pass an education reauthorization. Right? And we now aren't going to be able to pass appropriations bills because that has blown up. We are not functioning well, and the American people are not being well served. And Norm, I know you've thought about the connection of campaign financing, the way campaigns are paid for, to this, and I'd like to have you elaborate on it.
Thanks. Let me start by saying that one of the most significant and commendable provisions of the Bipartisan Campaign Reform Act was the Stand By Your Ad provision that David Price authored. I think it's now become familiar to most Americans, and it's changed the nature of campaigning. It's changed those commercials. When a candidate has to stand up in a television commercial and say to the camera, I am fill in the blank and I stand by this message, it makes a difference. And if you've watched any of the ads that have been out, the Super PAC and 501c4 ads in the presidential campaign, where the disclaimer at the end is this message paid for by Americans for a Better America, unaffiliated with any candidate or campaign. What you see, and we need more systematic research, but it's pretty evident on the surface, is scorched earth. Lies have now become the coin of the realm, viciousness when you don't have to connect yourself to it, and of course, the perfect opportunity for a candidate who is intimately connected to the super PACs to say, well, I had nothing to do with that, it makes it worse. I think it is demeaning the discourse even more. We live in a rough and tumble world. Shock to cut through the cacophony is going to be there all the time. But the Stand By Your Ad provision at least puts some broad boundaries around this, and those are going away. And one of the things that I fear so much is these groups are coming in with so much money that they can go to television and radio stations and roadblock all the prime spots by saying, I'll give you retail or 25% over retail. And candidates are going to be relegated to the second tier. They're going to be in the AAA ballparks rather than in the best places. And that's going to make it worse. What does all that do? It accentuates the tribal politics. This scorched earth campaign is going to make it that much harder to find bipartisan compromise when we come back. It is going to make voters view even less favorably all of those who are engaged in politics. I don't know how much lower we can sink below the 9% where we are now in approval, or 9 to 11%, but we've got a little bit of running room there. And the harsh negative views will increase, and that means the legitimacy of decisions that are made will come under challenge. So this is not just a matter of some of the really serious elements that we've made here, that we're back to the Gilded Age, and you've got people coming in, swooping in and spending money and getting their way in policy. It also challenges, it seems to me, the fundamental legitimacy of the system. And how members of the court who made this misguided decision can't see some of what they've wrought is beyond me.
I would love to add to Norm's comments, because it is not, Stand By Your Ad requirements are a great thing, but they're not enough. One of the central flaws in the Citizens United decision was this notion that corporations are just like humans. Corporations aren't just like humans, and these C4s that are going to be spending tens or hundreds of millions of dollars in this year's election on attack ads, and they will be doing the dirty work of candidates. They will be doing the attack ads. They can dissolve overnight. They can dissolve at the drop of a hat. And those of us sitting in this room today, God willing, we will be here in December. We will be alive. We will be held accountable for the actions we take between now and then. That can't be said for these 501c4 and other types of outside groups that, again, can dissolve with the filing of some paperwork with a Secretary of State's office at the drop of a hat. That's a big problem.
Representative Price, I also wanted to mention an example. There is visible negative campaigning, and I think the available social science research has shown that super PACs overwhelmingly engage in these negative attack ads. But there's also invisible negative campaigning, and there's a terrific example from your home state of North Carolina that's mentioned in the dissenting opinion of a case called Duke versus Leak. And in that case, there's an organization called Farmers for Fairness. This is in the North Carolina state legislature, which allowed these kinds of independent expenditures prior to Citizens United. And Farmers for Fairness supported a particular farm subsidy, and they knew that the legislature was going to consider this farm subsidy. So what they did is they made up a whole campaign of attack ads against particular legislators they knew were the swing votes. They then took these ads to the legislators and screened them behind closed doors and said, these are the ads. We will run against you if you do not support our position on this legislation. And some of these legislators changed their votes. Now, that's not going to show up on any disclosure. That's not, but that's just an example of the sort of a broader kind of corruption that, is a threat to our system that I don't think the Supreme Court ever envisioned.
I am honored to answer. You were my representative for 7 years. We're playing checkers now, and it's about to be chess. I mean, this hasn't begun yet. So right now we're thinking about ads, but we're in a technology and data era, so it's not just television ads. It's using the massive databases and access to data that some of the largest companies in the world have. It's not just going to come out in the form that we recognize of the last 30 years of campaign. We don't know exactly what it's going to look like, but we know that we're just beginning, and the level of sophistication in both threat and promise at every level of campaigns will be different. Who is going to run? Maybe we need somebody in this district because of the nuclear energy industry. Why don't we just plop down a promised several $1 million and get our candidate in the primary? This kind of money in primaries and local races is extraordinary. The conversation's been at the presidential level, but that's the least concerning. It's certainly small amounts of money have a much larger impact. And it's happening at the same time you see this radical concentration in economic power. So when Senator Kennedy proposed that no company be allowed to merge larger than $2 billion in 1978, we're talking about a much more decentralized economic scene. Right now it's much more concentrated, and we know the most concentrated industries spend the most on politics. So you see a combination of concentrated economic power, unlimited potential for use in the political sphere, and I'm a deep patriot. I love this institution and I love the promise of it, but it's very rare in human history to have a truly representative government. It's not the default state. The default state is, as you know from your own political science work, the default state is something much more like a kind of combination of oligarchic power where there's concentrated financial power really dominating politics. And there's this window here before the full threat of Citizens United is realized. And it's so important to act quickly.
Thank you very much. Mr. Van Hollen, for 5 minutes.
Well, thank you. Let me start by thanking you, Mr. Gonzalez, and Mr. Brady for organizing this forum on a central issue to the integrity of our democratic process. I also want to thank Leader Pelosi and my colleagues here on the panel and others who have focused on this issue, and all of you who just gave wonderful testimony about the urgency and importance of this issue. And I do think it's an absolute travesty that Republicans have refused to hold a hearing on this very important issue that is fundamental to the future of our democracy. I think, as everybody knows, we were able to pass the Disclose Act several years ago. It went over to the Senate, got 59 votes. In fact, in one of the terrible sort of unfortunate ironies of history, had Senator Kennedy not passed away, Disclose Act might well be the law of the land today, would have provided the 60th vote. But apparently our Republican colleagues want to keep people in the dark when it comes to hearings, just as they want to keep them in the dark when it comes to disclosing the sources of a lot of the expenditures in these campaigns. Now, you've all made very keen observations about Citizens United. As Mr. Ornstein said, some of the conclusions that were reached there could only be made by people who had no clue as to how the American political system was operating in the 20th and 21st centuries. And it's going to come back to haunt us unless we act quickly to fix it. I support a multi-pronged strategy. I think we have to proceed on all fronts. I also believe we have to engage in some political triage. We have to focus on where we're likely to be most successful in the short term as we also proceed immediately on other fronts. I do think disclosure is essential. I think the testimony today indicates that there's lots of money pouring into the system today that would not come into the system if those individuals and corporations and entities knew that their identities would become public. We've seen an awful lot of money laundering going on, and the Disclose Act is intended to get at exactly that. Trace the money laundering, require disclosure at all different sources and all different levels. And I think that we have a very sort of solid argument to take to the American people that, number one, voters have a right to know who is trying to influence the outcome of these elections, and therefore we should end the secret money in politics. And that is what we're attempting to do. Now, one of the cases, as you know, that may be taken up by the Supreme Court is the Montana case. I'm interested in your views on what opportunities there may be there or not to make our case. Mr. Ryan, let me thank you and the Center for your activity and efforts, not only on behalf of Disclose, and Mr. Ornstein, thank you for your support for Disclose and others, but also for your efforts in the FEC case. I share your view. It was an important measure, an important step, but we all know how long the processes can be dragged out in the FEC and through the court system, and it just goes to my earlier point that we need to proceed on all fronts, and we need to do it in an urgent manner. And I'm interested in all of your views on whether or not the Montana case provides any additional opportunity for us to revisit these issues.
I'm happy to respond to that. First, the Campaign Legal Center, my colleagues and I are right now working on a brief to be filed in that case on behalf of a bunch of transparency, pro-campaign finance reform organizations from around the country. Justice Ginsburg included a statement in a stay order that the court issued a couple of months ago indicating that at least some members of the court are perfectly ready and willing to revisit the court's decision. Citizens United, I won't predict whether or not there will be 5 or 6 votes on the court or more to change direction on Citizens United, but the door is open a crack, and we are going to take our best shot at it. There are a bunch of other very skilled attorneys and advocates from around the country, including the AG's office in Montana, that are working hard on that case. So I'm hopeful, but obviously no guarantees.
Mr. Van Hollen, let me step back for a second and say that when we were deep in discussions over BICRA and putting it together, there was a great deal of consideration made to making sure that this was evidence-based. We had a lot of work done on electioneering communications that were transparent campaign ads, on ads financed by soft money that was supposed to be for party-building activities that never mentioned a party, that were just aimed at attacking candidates. There was reasoning that went into that decision by Congress, and that was, I think, taken seriously by the court when it upheld the Bipartisan Campaign Reform Act. Reading Justice Kennedy and the Citizens United decision with not only redefining corruption in the narrowest way, which is dangerous and unconnected to reality, but with no evidence at all saying that independent money would have no connection to corruption or the appearance of corruption, or it wouldn't matter. And seeing what Richard Posner, a very well-respected conservative jurist, has written now, suggesting that that really doesn't make a lot of sense. And then looking at a Montana law that uses evidence from Montana to say, we don't want corporations doing this because it corrupts us, I hope that there are 4 justices who will bring this up, bring it forward, and then force the court at least to acknowledge that evidence doesn't matter to them.
Thank you for all your work on this, and I'm delighted about the multi-pronged approach. I'm always going to be pushing for prong 2, but there is what is the 1% hiding? There's a real sense of both privilege and secrecy together. It's important to fight. I do think it's important to demonstrate to the public that this Congress knows that transparency isn't enough. Montana's a great question. It's a really tricky one. I wrote an article called Facts in Exile about the Supreme Court sort of treating facts as this extra, a luxury. And whether or not in court or out of court, the Montana case provides an opportunity to talk in a really public way about the water cooler sense of corruption that we all understand. And what we mean when we say your minds are oriented not towards the public, your minds are oriented towards the 1%.
I think the Montana case is going to be, I think, absolutely fascinating because, as some of you may know, it takes 4 justices to grant cert to hear a case in its entirety. And I think many of us, the Brennan Center is also working on a brief in the Montana case, and I think many of us would welcome the chance to put on the record, exactly the sort of factual evidence that Justice Kennedy disregarded when he blithely stated, independent expenditures pose no risk of corruption. On the other hand, the flip side of that is it generally takes 5 justices which could be the same majority as in Citizens United, to grant a summary reversal of a lower court decision. And I think we're very much in a state of Supreme Court practice mystery as to whether the 4-justice rule is going to trump the 5-justice rule or exactly how this is going to work out. But in any case, as was referenced earlier, in the McConnell decision, the court considered hundreds of thousands of pages, including depositions taken by some of my colleagues at the Brennan Center, talking about what corporate CEOs expected when they gave soft money contributions and the way in which corruption can function below the surface. The Supreme Court did not take any of that evidence into account. I know that lots of the record in McConnell versus FEC was sealed for privacy purposes at the time of that decision. As far as I know, that's never been unsealed. There's a lot of existing evidence and there's a lot of new evidence from this new super PAC phenomenon that we certainly believe deserves a public hearing.
Thank you very much, Mr. Van Hollen. Mr. Ellison, for 5 minutes.
Thank you, Mr. Chairman. Also, thanks to the leader and all of our witnesses today. Just want to say for the record that earlier today we had a press event that involved over 20 community organizations that came together with several members of the U.S. Senate, double digits of House members, all coming together around the idea of an amendment strategy. On June 11th, there's going to be Resolution Week, in which municipal leaders all over this country are going to introduce resolutions to say, got to flip Citizens United. So there is a grassroots movement going on here, and it's very exciting, which leads me to my question. I got to believe that no matter what side of the political spectrum you may come from, liberal, conservative, the idea that your little microphone that all of us are sort of issued as a citizen is going to be drowned out by speakers that could, Mr. Ornstein put it better than I can, but, that could, you said, shake the seats in National Stadium because somebody has so many more dollars than another person. This must be something that there is broad cross-section of support across the country. What are the people saying about the need for disclosure, and what are the people saying about the need for amendment, and also what are they saying on the various political sides of the political spectrum? I mean, what are conservative groups saying about this stuff? I mean, I'm sure they got to be concerned about it.
Our impression from reading public opinion polls is that the public overwhelmingly supports disclosure of money in politics. Overwhelmingly supports it. And I think that support spans the political spectrum. When you come to the actual organizations, the actual members of the House of Representatives, for example, members of the Senate, we've seen flip-flopping, unfortunately, in my view, from some Republican members who for years and years, for decades, told the story of all we need is disclosure. Let's get rid of all these limits. All we need is disclosure. I was never sold on that because as soon as you allow incorporated entities into the system, disclosure becomes very difficult to achieve and sustain. But these same individuals who, Senator McConnell, for example, appeared on Meet the Press and went on about all we need, and this was fighting against the McCain-Feingold law. All we need is disclosure. Let's get rid of all these limits. Let's not pass this McCain-Feingold law. Fast forward a decade, many of the substantive limits, unfortunately, have been struck down, and they are changing their tune. And I believe that some of the Republican-oriented organizations here in Washington and nationally are following suit and changing their tune and realizing dumping secret influence buying money into the system is much to their liking. So, again, that's why we've seen trouble with the Disclose Act in 2010, why we're seeing trouble with the Disclose Act now in 2012. We need to hold folks accountable for their historical positions on these issues. Nothing has changed except their ability now to get away with legalized money laundering.
I think one of the great things about super PACs is there's such an easy phrase to remember that people now know what you're talking about when you're talking about campaign finance reform. I think thanks to Stephen Colbert, but thanks to a lot of media coverage of this. And so in my written testimony, I referenced some of the more recent polling that says that 69% of all Americans now support banning super PACs, and that support ranges across the political spectrum. We're talking about majorities of Republican voters, we're talking about majorities of Democratic voters and independent voters. So I think that what the people want and what the leadership want may tend to diverge here. But, I think that we can only take advantage of the momentum that's caused by this very high-profile unraveling of our campaign finance system.
Yeah, I want to echo that. I mean, there's extraordinary support for a public funding system now, even when the alternate arguments are presented. Extraordinary support for disclosure. But there's also extraordinary room for leadership. That if members of Congress do not themselves use their platform to make a fight out of this and make the fight clear, there's a softness in the support. People are looking for how to understand the post-Citizens United, post-financial collapse world. You saw the shifting numbers of support for Occupy Wall Street with the initial extraordinary high levels of support, and then an absence of national leadership on defining what this new economic and political system is going to look like. So there's both high levels, but there's also a lot of movement, and which is why public, clear expression of what government should look like, who people should be responsible to, what is possible in Congress is important, because otherwise you're going to lose people. You can name and act anything you want, and people aren't going to believe it anymore. So this kind of leadership is really key. Otherwise, I think you're not going to see the support without making the strong case.
Let me just make a few points. First, you can't underestimate the impact that tribal politics have now. I mean, I watched as the Disclose Act came up in the Senate, and I'd worked with Olympia Snowe on what was the Snowe-Jeffords Amendment that really was the provision singled out by the court and Citizens United. And to watch Senator Snowe, Senator Collins, Senator McCain, and others who had supported reform all join together with the rest of their colleagues to vote against this was stunning. But it's a reflection of Mitch McConnell's ability to keep his tribe together and to make it a top priority. And, of course, to get everybody to reverse course and now say that disclosure doesn't matter. So that's one important point to make. The second point is that public opinion does support disclosure and change. But, you know, there are a lot of things that overwhelming majorities of Americans support never go anywhere. I think we're going to see a change in this coming couple of months. If you were in a state where it's competitive in the presidential contest, you got a competitive Senate race and maybe something else going on, the months of September and October, there will not be a commercial on television that will not be a vicious attack ad. And for awful lot of Americans, you won't be able to escape it. And it's going to be a little bit like a goose being force-fed to get the foie gras. You're going to be sitting there, and this stuff is just going to come down your throat whether you like it or not. And I think we're going to see a very substantial reaction. We'll have to seize on it. And finally, I would say, we're not going to get it from leadership of conservative organizations. But I actually think in this issue and in many others, including some of the ethics questions, that some of these Tea Party colleagues of yours have no reason to be supportive of the huge money coming in that is going to sometimes drown them out when you get a different establishment setting. They're populists in a different way. And it is worth talking to them, maybe individually, and perhaps building some grassroots support for some changes here. It's not going to come easy, but it's going to be easier to get than it will coming from the usual suspects on that side.
Any time for a quick follow-up, Mr. Chairman? So now I want to ask you about shareholders. I think this is an interesting group to sort of understand how they see this, because I think this is pointed out several times. You know, when you send your money to your 401k, somebody's using that money to say something that you have no interest in them saying. Yet if you were in a union, as Representative Brady pointed out, you'd at least have some say on that. They're fighting us on say on pay and golden parachutes. And yet shareholders at Citi rejected a compensation package. So I guess my question to you is there any energy, anything going on among shareholders saying, wait a minute, you spend my money on stuff, you're supposed to be trying to make me some money, take care of my retirement. Why in the world are you beating up on this person and that person and the other? It's not helping me out. Care to address this issue?
There is some work being done, some important work being done on behalf of shareholders. The SEC was presented with a rulemaking petition that was open for public comment, received widespread public comment, that urging the SEC to promulgate rules requiring improved disclosure of corporate political spending. Representative Capuano has introduced the Shareholder Protection Act, which has a national coalition of organizations advocating its adoption, its enactment. And that would provide, or would require corporations to obtain affirmative approval from shareholders before making big corporate political expenditures. So work's being done, national coalition working on it. Very important issue that you've highlighted.
I suspect this is where I'm going to differ from some people on this panel. I do not happen to think that pursuing the shareholder strategy is a good idea at this point. I do not think that, basically, I think of it a little bit like Dodd-Frank. The country is responding to Dodd-Frank saying, you didn't do anything about too big to fail. I don't know if you've seen the recent polling around this. And at the time, there was a sense, okay, no, we can manage our way. We don't have to, we can manage our way and we can figure out something and we'll get credit for having figured out something. This is bigger than shareholder protection. We actually have to restructure the way campaigns are funded. If you don't do that, everything else is a little bit Baroque on the sides. At the same time, I also think that if you perfect the agency relationship between the shareholders and companies, that doesn't necessarily mean you see less funding. In fact, the rational company might spend a lot more money on campaigns than they do now once they've really figured out this chess game. So I admire the creativity here, but I actually think that we should be focusing on the real game, which is how campaigns are funded, and returning to pre-Buckley.
I'm not sure that that's, it's not the top priority, but I would disagree a little bit with Zephyr here. I actually think most public companies don't want to do this. They did not react with anger at BICRA. They don't want to get caught in a couple of terrible dynamics. One is where you have a party shaking you down and basically saying, whose side are you on? And if you don't pony up the money, we're going to make you pay. The second is the situation that we saw with Target. And we're seeing now with ALEC, the American Legislative Exchange Council, this group that basically has, talk about corruption, come in with ready-made laws that lawmakers are perfectly happy to just channel right through and get something in return, that a lot of companies gave to, and now it's when that's being disclosed and all of a sudden they realize that they paid for the stand your ground laws, they're saying, whoa, I don't want to be a part of that. So I believe that disclosure will change the role of a lot of public corporations. It's not enough. And the fact is that even with billionaires and individual money, was very different before Citizens United, when you as an individual had to go out there if you wanted to put large sums of money in and do it all yourself, where now you can just give it to Karl Rove or give it to some other group and they do all the work for you. So we need a lot more than that. We need a short-term strategy that isn't going to involve overturning Citizens United. We need a medium-term strategy that can be ready with the next product when that happens. Maybe we need the long-term strategy of looking at a constitutional amendment, although I'd prefer to work in other ways. But you can't abandon any of those, and you can't abandon every avenue, whether it's the FCC, the FEC, the SEC, or the IRS, or legislation, or some of these other vehicles.
I'd just briefly like to address that. I agree that this is only a partial solution. For one thing, publicly traded corporations are only a very small part of the problem that we're talking about. But I do think that, we do need to look at creative avenues to encourage corporate disclosure, just for the sake of my 401k fund. And I think we're used to thinking of corporations as monoliths, like, oh, the corporation is spending money in politics and they know about it all the way down. They often don't know about it. Often there's no requirement that political spending be disclosed to corporate boards. There's a multinational pharmaceutical corporation that has become a leader on the shareholder disclosure front because they found out that one of its, mid-level managers was spending corporate funds to support an openly racist candidate in Mississippi. And he was doing that without the knowledge of upper management. It's that sort of, shareholder disclosure makes sense for a lot of reasons. It's not a solution to our current problems of money in politics, but it is something that's important to do in its own right.
Well, thank you very much, and the chair's going to recognize himself for 5 minutes, and thank you for your patience. But quickly, and I want to follow up on something that Dr. Ornstein pointed out, is that some people may fear that there may be individuals on the other side of the aisle. They may not relate to the fears that we feel. Citizens United has truly diminished the role of the individual in the election of their elected officials. No one's really recognizing that. And here in Washington, we're so caught in the middle of this thing, and I'm not real sure that we've ever gotten that message out. Now, I understand that an individual can work on my campaign, knock on doors, put up the sign, have the bumper sticker. They can also contribute because the way you communicate today obviously is an expensive thing. But there are limits as to what the individual can contribute to Charlie Gonzalez if I were to be seeking re-election. Yet, and it also impacts what happens in the future when candidates are thinking of running for office. And this is what I mean. Let's just say my good friend Keith Ellison, I'm now a private citizen. I want to help Keith. I love Keith. So I want to contribute. So I'm going to be limited to contribute X amount for the primary, X amount for the general election, maybe $5,000 as an individual. But if I have a whole lot of money, and I want to help Keith, what would you suggest would be the best way for me to do it? Should this exact circumstance we find ourselves today on shell corporations, the super PACs, the 501c4s, what is the best way for Charlie Gonzalez, private citizen, to make all his money really felt, because I want to help Keith Ellison. He's not going to coordinate anything with me. Maybe his former campaign manager may be running that super PAC, but please don't draw any conclusions. What is the best way for me to get lots of money to support Keith in his reelection?
I would ask you whether or not you're willing to be disclosed publicly, whether or not you're willing to stand by this support. If you are willing to stand by the support, you can write an unlimited sized check to a super PAC, and that super PAC can spend every penny that you give to that super PAC to advocate Representative Ellison's election to office. You could, of course, go down to local TV or radio station or to the stations in Representative Ellison's district and make those ad buys yourself. You've been free as an individual for decades, forever essentially, to do that. But if you don't want to be disclosed for this support, then you identify a 501c4 group. If one doesn't exist, you encourage some friends to create it, and you write your unlimited check to that C4 group. You refrain from writing on the memo line of that check, use this money to air ads for the reelection of Representative Ellison. You refrain from specifically designating your donation to the C4 for any particular purpose, and you will remain undisclosed. The C4, in turn, can spend your money 49 cents out of every dollar you give it on hard-hitting express advocacy ads urging the election of Representative Ellison, and we'll spend the other 51 cents on ads that are nearly as hard-hitting, sham issue ads that either attack an opponent on the basis of some issue, but certainly identify the candidates in the race, yet don't contain words of express advocacy and therefore don't fall under the rubric of Canada election intervention for tax law purposes. That's the way to do it, and it's your decision whether you want to remain anonymous or be disclosed.
Anyone else?
What I find kind of touching about both your question and Paul's response is we're talking about this as if it's a hypothetical. But we already know, so the poster child of this campaign season so far has been Sheldon Adelson, who, as we all know, has given upwards of $10 million to support Newt Gingrich. But there are two $10 million checks that were both written to Crossroads GPS, and we don't know the name of the person that was on those checks. There are two separate checks written for $10 million apiece. We have no idea who that person is, or if it's even a person, or if it's a major corporation behind this. This is already happening. This is an avenue that sophisticates have figured out. And Adelson, at least he's spending his own money. At least we know his name. I think the biggest problem is when they're not spending their own money and we don't know their names.
Anyone else?
So I'm going to, I'm a law professor, so I'm going to fight the hypothetical. I know these are wonderful answers, and I hope nobody hears them because they're good advice. But I just want to respond to something also that Norm suggested earlier. I think at first, corporations, I would love it if we just stuck with the wealthiest individuals trying to figure this out. It's a terrible situation, but it doesn't deal with the real threat of concentrated power used strategically. We're 2 years in. I think it was Texas Home Builders who use the first company that actually did it itself as a company, using the ability to have independent expenditures. 2 weeks ago, we have the first banking super PAC because Congress doesn't know to be scared of the banks. It was in the press release, I believe. We are just at the beginning of strategic corporate action. And if they're then following the same strategy, now we're talking real money, and we're also talking money that has a particular ideological bent, so that you no longer see the range of ideological views that Americans hold.
Let me answer your question in a couple of ways, and it will get also at Representative Price's question. If I'm sitting there as a member of Congress, and I know that American Crossroads GPS, if the presidential contest doesn't turn out to be completely close, is going to turn all of its resources into House and Senate campaigns. And I also know there are going to be others out there. And I'm worrying about somebody coming in at the end and spending $10 million against me. Of course, I'm going to go out there and try and raise as much as I can in $2,500 increments. There are limits to that, especially because everybody else is going to be looking at the same individuals. So I'm going to try and find a sugar daddy. I'm going to look for somebody who will do for me what the others would do for against me. And to get those, maybe a billionaire who's there ready to be tapped if necessary. If not, there'll be something in return. And so we're going to see a whole lot of additional corruption as people are going to make side deals just in case. And the money may never be spent, but once again, it'll have an impact on the legislative process. And then another element of what David asked. You know, it really used to be in the days when I first got here that you could see a lot of members of Congress who were recruited to come here by people in their communities who went to them and said, "You've done wonderful things. You've built a great reputation. How about spending some time in public service?" Now, if I wanted to go to somebody like that now, I would say, it's time to spend some time in public service. And here's what's going to happen. The first thing is, brace yourself for the $5 million that'll come in by your opponent and other related groups designed to strip the bark off you and destroy that reputation you've spent your career building. And they'll know they've succeeded when your kids come home from school crying and say they can't go back anymore because of all the embarrassment that they face from their friends and fellow students. And you'll do the same thing, and then you'll get elected, and nothing's going to happen around here because the two parties are completely gridlocked, but you'll spend every spare minute that you aren't racing to get a plane to go back home spending money, raising money for the next time around. It is a miracle under these circumstances that we get good people like you who continue to do this. And I don't know how much longer, because the ones who are incentivized to do this now are the ones who are driven totally by naked ambition or by an ideology that makes them certain that they have the right answers and that it's all black and white, and especially those people who pop up and say, "I'm not like the rest of those bozos up there, I'm not a politician." So we're leaching out the people who are here to solve problems, and we're encouraging the worst sorts to come in. And this is maybe as fundamental a problem in terms of the future of this institution as anything else. And it's been driven by a lot of things, including a debasement in the culture more generally, where lying is no longer treated as a shameful thing, and you double down on your lies to get around it, but also by what Citizens United itself and its progeny have wrought.
Well, thank you very much. And I know we've gone over time, but if you'll just indulge us for a couple of minutes, I'm going to see if my colleagues have a very short follow-up, because we've had some great discussions since they were able to pose their questions. I'll recognize Mr. Price.
Thank you, and I'll ask a very pointed question, one on a narrow topic and the other somewhat broader. But I do appreciate especially what Professor Ornstein just said, getting at the broader corrosive effects of this system on this institution and on American politics generally. I don't. That isn't a strictly legal argument, but it sure is an important one, and that's also what I want to ask about. First, a very narrow question. I like your quote, Ms. Teachout, about the limits of disclosure. You can't X-ray a patient back to health. That's a good one. I want to remember that one. The limitations of mere disclosure. However, we are, as we've all said, we do believe that at a minimum we need to push for disclosure, and that, of course, there's no question that would pass legal muster. There is a problem. Stand by your ad. You know who's standing by his or her ad, the candidate, or with the party leader. That's not so clear with Americans for All Good Things. So the device that we've come up with, I did this in my Stand By Every Ad, the latest iteration of Stand By Your Ad, the Stand By Every Ad Act, and it's the parallel provisions in the Disclose Act. We've said you got to put on the screen those top 5 donors, one way or another. Flash up there the top 5 donors, or have a trailer showing the top 5 donors. Is that the best we can do? Is that the equivalent of what it would mean to saddle someone with personal responsibility for the ad? Okay, the somewhat broader issue, you know, there is a difference here, I think, between the legal arguments and the broader political arguments, and Norm Ornstein just articulated one of them. But we talk time and time again about voices being drowned out, about the voices of ordinary people, of ordinary citizens, just coming to count for nothing. I mean, it's not just about corruption. I mean, I guess the most powerful legal argument is about corruption. Is that true? I guess that's my question. But in legal terms, how do we translate this intuition we all have that this is just a disaster for democracy? The voice of these few wealthy people becomes so disproportionate, so overwhelming, drowning out everything else. I mean, there's surely no way that can be healthy for democracy. Yet, I think our legal arguments often kind of go to the corruption issue and don't do much else. I guess I'm just asking what the political argument, of course, is one thing, and the legal argument is another. But is there a legal hook for this intuition we all have that you simply cannot have a few voices drowning out the others?
No, I represented the Arizona Clean Elections Commission in the Supreme Court case McComish versus Bennett, which was about the Arizona public financing system. And I remember sitting up there and feeling my heart sink when Chief Justice Roberts said, you know, I was looking on the commission's website this morning and I came up with I saw a reference to level the playing field, and that makes this law unconstitutional. So we're in a situation right now where the Chief Justice of the United States thinks that equality is somehow unconstitutional. And this is, I think, the distorted vision of the Constitution that's been promulgated in decisions like Citizens United, the idea that the First Amendment and ideas of equality and democracy are irrevocably at odds. The reason that so much legal argument has focused on corruption narrowly is because that is what the Supreme Court has defined the only legitimate interest in regulating campaign ads to be. They have said, no, we don't care about, you know, hearing other voices. We don't care about equality. God forbid we care about leveling the playing field. We don't care about saving candidates time so that they're not constantly dialing for dollars. We don't care about the integrity of our electoral systems. All we care about is this very narrow version of corruption, and I think that that's what we need to push back really hard against.
So I like the 5 names. I would like it even more if they had to themselves say that they stood by the ad. But I think it's a wonderful way to have actually the names up there. I think this is creative. This actually also goes to Representative Van Hollen's question. Majority of the Supreme Court doesn't actually think corruption is an idea that makes any sense at all. They say 2 things. One is corruption is the only interest that can be used to outweigh this First Amendment interest, not our founders' First Amendment, this sort of nutty outer space First Amendment. And then at a core level, they actually don't know what corruption is because in Kennedy's opinion, he expects and accepts, as does Scalia, that members of Congress will be dependent and responsive to donors' interests as opposed to the public interest. They, at a core philosophical level, do not believe in the public good. And they are totally at odds with the country. The country still believes in the public good, in the possibility of public interest. But for a whole bunch of reasons, there's an ideological position that doesn't support that. I've been sort of interested in this question, too, about legal hooks, and I've been interested in possibly Congress coming back and redefining bribery, because one of the things Kennedy says in Citizens United is, don't worry, our bribery laws will deal with that. So what if Congress came back and said, your 1991 case where you said campaign donations aren't treated by the normal bribery laws, we're overturning that because that was just a matter of construction. We want to say that campaign contributions and independent expenditures should be treated by the normal wink and nod provisions of our federal bribery and extortion statutes. There'd be an interesting back and forth with the Supreme Court, but what I think that would show is that this Congress understands that we as the public do believe that there is a corrupt institutional problem here, and bribery might be the right word for it.
I'll respond to your question with respect to the stand by your ads. Is that type of provision enough to create accountability? I'm a strong supporter of the stand by your ad provisions, the expanded version that you've advocated, but it's not enough because one of the ways that voters get their information, one of the ways that people in our society get their information is through the press, through journalists analyzing data that's crunched by through the hard work of nonprofits like the Center for Responsive Politics that attach and slice and dice this contributor data according to occupation and employer and interest groups. Those stories reach voters and are just as important as seeing the name of 5 folks on the face of an ad at the tail end when they may or may not be paying attention. It's really important that all of you continue to support, to strongly advocate the improvement of collection in fine-grained data, of contributor data that's missing now because disclosure on money going to C4s, for example, is not required. That data is really vital to help the journalists who are working really hard to improve transparency and tell the stories, the bigger stories, about who these interest groups are, why they're spending, what they're spending. And your work can really help facilitate that.
Let me say, I'm a strong supporter of your of the stand by every ad provision. A part of the reason being that the disclosure regimen that affects super PACs is such a farce now. Anyhow, you know, you get it every 6 months. It's delayed. It's not there for voters to be able to take into account when the decisions are actually made. At the same time, I would come back to the Federal Communications Commission. They're in the process of putting together a regulation, which they have done very carefully and I think very conservatively, so that small TV stations won't have a burden. But basically, all stations now are required to keep information on the funders of ads in a public file. That public file usually is in stacks of papers stuck in a back room. The law says that citizens have access to it. Try and get access. Go to a local television station. 9 times out of 10, they'll tell you no. But there's no reason why it should be in that setting. And for the kinds of data that Paul is talking about, it would require entities like the Center for Responsive Politics or the Brennan Center to go to every single station and spend hours looking through files. What the FCC wants to do is to require the larger stations now in the biggest markets to put all of that data online, and it'll be accessible on the FCC website. It actually will cost those stations less. You won't have to get the data, walk it across a room, put it in a file. You just punch it in, and almost all of them already have websites, and they have Excel files in which to do this. But they're facing huge pushback from television stations. Television stations will make billions of dollars in additional profits because of what's happened in this campaign system. The idea that they won't disclose for the public the sources of those ads is outrageous. You need to fight against the broadcasters and provide backing, write letters, and do other things to tell the FCC that they're on the right track here.
Wrapping it up, Mr. Van Hollen, you have a follow-up?
Thank you, Mr. Chairman. I just want to thank all of our witnesses. I think they've made excellent points. You know, one of the problems with the numerous court decisions and the direction we're headed is not only has it provided a whole new source of unlimited amount of money flowing into these campaigns, it's putting a lot of pressure on the very fragile campaign finance system we had because, as many of you have said, when you look at the situation where you've got these limits on contributions to candidates and their campaigns versus the unlimited amounts that can be given to super PACs, campaigns and candidates are like fighting with pea shooters against bazookas these days. And it goes to the fundamental, one of the fundamental problems with the court decision. All of you mentioned it. Mr. Ornstein mentioned it right at the beginning of his comments, which is the idea that somehow if Sheldon Adelson gives more than $2,500 to Newt Gingrich in the primary and then more than $2,400 to him in the general, that will somehow have a corrupting influence or the appearance of corruption. But if Sheldon Adelson puts $5 million to the Newt Gingrich PAC, that won't, even though he's meeting with them and as all his campaign guys are involved. I mean, it just defies common sense. And how we could have had a Supreme Court that was so out of touch with reality on this issue just defies logic, and we're all going to have to work very hard. But I think this has been instructive. With respect to the other point the Supreme Court made that defies logic with equating corporations with individuals for these purposes, I would just say to our chairman, and since he's from the state of Texas, that one of our colleagues remarked that they would believe that corporations are individuals when your state of Texas executed a corporation. So, you know, this is, it's just uncanny, the sort of air of unreality that the court had on all these issues, and we're going to have to fight to make the changes necessary to preserve the integrity of our democracy. So thank you, Mr. Chairman.
I want to thank the witnesses. Hopefully we have provided you a very unique experience in your professional experience, lives, to say that you may have testified in court before as an expert. You may have testified before a hearing as an expert, but today you testified before a forum. I'm not really sure what that means, but hopefully that it's going to be substance over form, and I think we've had a lot of substance today. Thank you. I want to thank my colleagues and their staffs because they worked really hard. I want to thank especially my staff, but also the staff for the Committee on House Administration. And with that, this forum will stand adjourned.